and good afternoon, and welcome to our Beat Bite session, The Taxman and the Beat Goes On, Property and Income Tax Issues Impacting Community Associations. I am Melissa Francis, an Associate Attorney with Zelmansky, Danner, and Fiorito, and I will be your moderator on Facebook today. Our moderator on Zoom today will be ZDF partner and our captain of this yellow submarine, Gregory Fiorito. If you have questions on Zoom, you can put them in the public or the private chat for me, and I will ask those questions of our presenters. If you have questions on Facebook, please put them in the comments for Greg, and he will ask those of our moderators or of our presenters. If you would like a copy of the presentation, if you could email me in the private chat, I will email you a copy of the presentation after we are finished today. So I am excited to bring you our presenters today, fresh from their exploration of the octopus's garden in the shade. They are now back in our Mount Clemens office, where they spend most of their days. They bring with them over 50 years of experience in real estate, condominium, and tax law. And I will now turn it over to Attorney Richard L. Wagner and Attorney Brooke Jordan. Thank you so much for joining us, and enjoy the presentation.
Thank you, Melissa. And greetings and salutations to everyone who is watching. And good afternoon or evening or morning, depending upon where you are and when you're watching, as our excellent IT attorney team of Melissa Francis and Stacia Miller make sure that we are available online in various media, as she's already outlined. So basically, grab your beverage, your sack lunch, or your dinner or breakfast or whatever, and sit back and relax, because we're going to take you on a journey. And this journey involves taxation, and it is another part of our continuing BEAT programs to discuss the impact and effects of COVID as to the economic impacts. We've talked before about the various amenities, the documents, collections, and other impacts on associations. So today we're going to talk about taxes. And now you ask, why are we doing taxes up? There's just nothing really good about taxes. Well, that's not particularly true. There's good and bad in taxes, like probably everything else in our life. Recently, you may have heard that they've announced that you're going to have an extra month of time to pay and file your taxes. And there has been some consideration given to extension of payment of taxes on current taxes, but not pass-through taxes. So why are we talking about this with reference in terms of COVID? Well, people are out of work. People are locked at home. People may have lost their business. They've got reduced income. They can't pay their assessments, their condo assessments, their HOA assessments. They can't pay their mortgage. They can't pay their taxes. So what happens? How does this impact the association? What should we do about it? We're going to give you a general overview of the tax system and the applicable provisions to condos and HOAs and any property ownership in general in the state of Michigan, if you own any real estate. We're going to provide you with the technical of how or what to do when you are taxed, and when you're wrongfully taxed as to classification, or when you're improperly taxed as to valuation, including the procedures for remedies, which we'll discuss tax foreclosures and mortgage foreclosure. So with that being the outline of where we're going with this journey today, we're on the first slide tells you about the basics of the General Property Tax Act, which controls basically everything in the state of Michigan as terms of property taxes on property. And as the heading states, it's an act to provide the assessment of rights and interests in property and levy of taxes on property for the collection of taxes levied and so on and so forth. The key thing is 211.1 that says all property, real and personal, within the jurisdiction of the state that's not expressly accepted can be subject to taxation. In other words, the king gets his due no matter what, okay, unless there's an express exemption. When is this determined? Well, the tax day is normally December 31st of the immediately preceding year. What we've attached in the outline is Appendix A, which is a number of the citations to the Tax Act, a general outline of the provisions of Chapter 211, and some special items that we thought may be of interest to you. We're not going to go through all of those, but we talk about 211.2 is determining the status of when it's taxed. 27A has the classifications of different kinds of tax. And 34C addresses residential issues. And like I said, moving on to the next slide, unless it's expressly exempted. Next slide, Melissa. There you go. The property tax exemptions. Brooke has put together, or excuse me, Brooke and Melissa put together a little chart of different areas of where there are property tax exemptions. Now, in that entire act, there's a whole list of exemptions aside from these like general areas. That's MCL 211.7 through 211.7 double X. So it goes all the way through the alphabet once and then through the alphabet again to double X, listing all kinds of different exemptions. For example, you will have perhaps exemptions for the elderly on 211.7D. You've got right-of-way exemptions on 7E, seawalls if you happen to have a marina in your community, solar and wind, state tax exemptions, poverty, that's my favorite because I keep trying to claim that one, but that doesn't work very often. Homestead exemptions for school taxes under 7C, and then the definitions of all the things for real estate property. So you can see the Tax Act is pretty complex. Appendix B that Brooke has put together gives you a whole list of the divisions of the Department of Treasury, and you're free to look at those or send us questions if you have any of it. But otherwise, it would obviously take up way too much time. We'd be in 7-hour seminar rather than just an hour. So we thought we would bring that to your attention. The next slide. It says, I told you the costume was too scary. Property tax man is at the door, trick or treat. And sometimes the people have that reaction. So what are the statutes governing taxation of property in the homeowners and condominium statutes? Well, as we talked about the homeowners associations, and if you own property in general, even if you don't have an association where you live, the General Property Tax Act, the GPTA 211.1 is the act that applies. It states that all lots in the subdivision are assessed and taxed independently. There's no common taxation except to the extent that the tax assessor believes that there's some improvements or benefits to a particular lot. So there's no common. It's basically all basically what's on the lot. In contrast, the condominium association is determined taxation in accordance with the Condominium Act and the General Property Tax Act, which is 559.231. Each individual unit in a condominium association is subject to the special assessments and property taxes of the municipality. No taxes or assessments are levied independently against the common elements, either general or limited common elements. So in other words, whatever the common area is, it's taken into consideration and tacked on to your unit, as opposed to it having its own tax for parcel ID number. So they cannot tax your porch or your deck or anything, a limited common element, except only in the consideration of the valuation of the unit, a unit that has a deck versus a unit that doesn't have a deck, okay, that kind of thing. So on the next slide, we see that the general rule is nonprofit associations are not taxed because they really don't typically own land. There are exceptions to that, and a lot of times what you may see is land that is deeded to the association for a clubhouse or tennis courts or a playground area or a beachfront area or the marina type area. That will have an independent tax ID number, and the association will be responsible to pay for that tax. Easements or dedications are generally not independently taxed, but they may be taken into consideration for purposes of determining the valuation on a particular piece of property. Right. Items that are subject to a public right-of-way, that is exempt. The fact that a public road runs through your property, that's not going to get added to your taxes because that is specifically exempt. If you remember in our first slide, we talked about everything's taxed unless there's an express exception. Leases. Sometimes leases can be taxed if they're over 35 years, and we'll talk about that a little bit later. In the Walgreens case, there was a case where the tenant under the lease was trying to challenge the tax assessment and basically appealed to the local board of review. They said, no, you're not the owner. Unless you have something in writing from the owner, we don't want to hear from you. And they said, well, that's baloney. We've got to pay for 4 years of taxes here, and we want to challenge this tax assessment. That was taken to court and appealed to the Court of Appeals, and the Court of Appeals says, no, you've got to be the property owner or have something in writing for you to be able to challenge the tax assessment. We also want to point out to you that it's important for you to consult with your financial advisor, your CPA, with reference to the association. That the association, even though they're nonprofit, they may still have to file income tax returns, either 1120 or 1120H for a homeowners association. The distinction being typically the nature and extent of the income derived. In other words, if it's income solely by means of assessments, it's part of your recorded documentation, then that's not really income because you're a nonprofit and you're paying your expenses. If it is income derived from rentals of the pool, or the clubhouse, and so on and so forth, the common amenities, then that's going to be treated maybe perhaps a little bit differently and taxed on a different level. So that's why we like to point it out to you, where it's important for you to talk to your tax consultant. With that, we're going to get into what happens, how you're assessed in that, and Brooke is going to lead you down the merry pathway of what you need to do when you get a tax assessment.
Hi, so what happens in the association? Every year, every property should receive a notice of assessment, taxable valuation, and property classification around March 15th. Although it states this is not a tax bill, please do not disregard it. This notice must be provided to you 14 days before the local board of review is scheduled to meet. If you see a change reflected on this notice, please do try to contact your local assessor to better understand why he or she made this change. Some examples of changes include there's been a transfer of ownership, or it's been taxed this year and it's never been taxed before. An example of that would be with a common element. Another situation is if it's a change in classification. Last year it was classified as a residential, this year it's classified as a commercial. If you disagree with the taxable value, the state evaluation value, the property classification, or the transfer of ownership, you must file a protest with the local board of review. Would you please switch the slide? One more. And another. Perfect, thank you. You must file a protest with the local board of review. If the March local board of review does not find in your favor, you may appeal the petition to the Michigan Tax Tribunal by July 31st of the current year. A July or December board of review decision may be appealed to the Michigan Tax Tribunal by petition within 35 days of its decision. The Michigan Tax Tribunal is divided into two divisions, the entire tribunal and the small claims division. Any case can be filed in the entire tribunal except for principal residence and qualified agricultural exemption appeals. Now, with regard to the small claims division, it only has jurisdiction over proceedings which are residential property exclusively, or property other than residential with a taxable value of less than $100,000. Please note that a person whose claim falls within the jurisdiction of the small claims division has the option to elect to proceed before either the small claims division or the entire tribunal. In general, the small claims division is less formal than in the entire tribunal. A formal record of hearing is not required. The location of the hearing is usually in the county where the property is located. By permission of the court and mutual consent of the parties, the hearing can take place at a location agreed upon, or even by use of the telephonic or video conferencing equipment. After completing the hearing in the small claims division, the hearing officer issues a proposed opinion and judgment. Each party may then file exceptions to it, which are then reviewed by an entire tribunal judge who issues a final opinion and judgment. Now, what do you do if a division of the Michigan Tax Tribunal does not find in your favor? If you're in the entire tribunal division, you may file a motion for rehearing or reconsideration from a final opinion. This motion tolls the appeal period, and a party has an additional 21 days after the decision to appeal the decision or order. If you're in the small claims division, then the parties may file exceptions to the proposed opinion and judgment within 20 days from the date of entry. In general, though, a decision or order by the Michigan Tax Tribunal is final and conclusive as to all parties, unless reversed, remanded, or modified on appeal. The Michigan Tax Tribunal can order a rehearing upon written motion made by a party within 21 days after the entry of a decision or order. Now, if your appeal to the Michigan Tax Tribunal is unsuccessful, you may appeal this decision to the Michigan Court of Appeals by right. But please note, if you receive a notice or a tax bill, consult with your attorney or timely file an appeal. Okay. There's some examples of when the association was wrongfully taxed but successfully challenged it. The first case we're going to talk about today involves garage spaces. In Corolla Condo Association versus Chappelli, the Wayne County Treasurer foreclosed on the limited common elements that were identified as garage spaces in the master deed and obtained a judgment of foreclosure. The Condo Association filed an action for injunctive relief and quiet title, asserting common elements are not subject to taxation and therefore could not be subject to tax foreclosure. The county argued that once a judgment of foreclosure is entered and the notice requirements for a sale are met, the association cannot bring an action for quiet title. Fortunately, the Michigan Court of Appeals found in favor of the association, relying on the Michigan Condo Act, which provides that the general common elements of a condo project are not subject to separate taxation, but rather property taxes related to the general common elements are paid by the co-owners in accordance with their percentage of value as set forth in the condominium's master deed, as part of their obligation for payment of property taxes on their individual units. In this regard, the Michigan Condo Act provides property taxes shall be assessed against the individual condo units identified as units of the subdivision plan and not on the total property of the project or any other part of the project. Further, except to the extent otherwise provided in the Michigan Condo Act, the undivided interest in the common elements allocated to any condo unit shall not be altered, and any purported transfer, encumbrance, or other disposition without the condo unit to which it appertains is void. Because of this, the Court of Appeals held that because the garage units were limited common elements, they could not be taxed separately from the condo units. Further, the Court of Appeals concluded that since limited common elements were not subject to taxation, they therefore could not be subject to tax foreclosure by the county. For these reasons, the Court of Appeals set aside the judgment of foreclosure as void as a matter of law. Again, in Paris Meadows, the court held that the separate taxation of the common elements, except through the condominium units, is prohibited by the Michigan Condo Act. And at this point, Richard's going to discuss undeveloped land in a condo project.
Okay, now we're going to get into some of the meat in terms of what happens with the association. Interesting, the Cove Creek Condominium Association is a case that many of us practitioners waited years for and watched a lot of debates about it. It involves Section 67 of the Act, 559-167. Before the 2016 amendments, Section 67, if you look in your master deed, it usually says that the developer has the right to add land, add units, and so on and so forth, convert general common elements into units, or a period of 10 years or 6 years after the exercise of any of those rights to expand or withdraw land or diminish the size of the condominium. Before 2016, the time period was 10 years from the commencement of construction, not from recording on a master deed. It was commencement of construction. So as the association attorney would have to double check is, okay, when did he pull a permit? When did he start construction? Because we want his clock to start running and turn it off if we can't have his time period expire. A lot of the developers got together and complained about it. They said this isn't fair, especially after the circumstances of 2008 with the real estate crash and so many undeveloped portions of land, that the association is sitting on general common elements, which eventually maybe the association might work out a deal with a new developer, but the old developer lost all rights to construct any units because that's what happens on the expiration of those time periods. So what they did with the post 2016 amendment to section 67 is they changed it to, well, it's 10 years from the period of recording in the master deed, or 6 years from the last amendment exercising any of the options that a developer has to expand, contract, or withdraw land. But in this particular instance, in the former instance in 2016, it said the land, if you don't do all that, the land remains general common elements. Too frequently, judges and attorneys will go and say, well, it converted. No, that's not what the statute said. It said it remains general common elements. Well, after 2016, they turned this around. They said that the developer can withdraw the land or convert the general common elements to must be built, or they have a process of the membership to vote to have it remain as part of the project, but it would revert to general common elements. So now we went from it remains general common elements to it can revert to common elements if you file the affidavit and do the procedures that are outlined, sections 4 and 5 added to the act in section 67. So now it's important for you to discuss with your council, especially if you've got some undeveloped land in your community in a condominium, whether or not that land is available for them to carry on, add units, or whatever they want to do, whether their time period has run or whether or not you need to do something to have it revert to general common elements, in which case the developer has to be notified and so on and so forth. So we're going to, with that, we're going to move on with Brooke is going to tell you what happens with the property tax foreclosure process in the next slide.
What if you fail to pay property taxes to the city, the township, or the village and do not timely appeal? In general, the General Property Tax Act provides for a tax lien on the property and ultimately permits recovery of the unpaid taxes and costs through foreclosure of the lien and sale of the property. Now, property taxes become a debt due to the local unit of government on tax day, which, as Richard explained, is December 31st of the immediately preceding year. Unpaid summer taxes become a lien on July 1st, whereas unpaid winter taxes become a lien on December 1st. On March 1st, taxes due in the immediately preceding year that remain unpaid are returned to the county treasurer as delinquent. Delinquent tax liens are forfeited to the county treasurer in March of the second year of delinquency. And this tax lien is foreclosed after an administrative show cause hearing and a circuit court hearing the following February at the end of the second year of delinquency. Please note, the court may withhold property from foreclosure for a period of 1 year or extend the redemption period if the owner is a minor heir, incompetent, or undergoing a substantial financial hardship. Next slide, please. Now, the judgment of foreclosure is followed by a final redemption period that ends on March 31st. If the property is redeemed by the owner before then, he or she acquires no greater interest than what they would have had the property not been forfeited. And if the property is redeemed by someone other than the owner, that person is entitled to only a lien for the redemption amount. This lien is in addition to any other lien or interest the property may have in the property. However, the lien has the same priority as the existing lien, title, or interest. Now, before entering a tax foreclosure judgment, the General Property Tax Act provides procedural safeguards to afford those with an interest in the property notice of the foreclosure by mail, by publication, and by a personal visit to the property. And it also provides an opportunity to be heard via show cause hearing and a judicial foreclosure hearing. But once the foreclosure judgment is entered and the appeal period expires on March 31st, fee simple title in the property vests in the foreclosing government unit without any further redemption rights. The sole remedy at that point is monetary damages, money, not the property. Last week, the Michigan Supreme Court held in the case 2 Crooked Creek LLC versus Cass County Treasurer that any notice, constructive or actual, is constitutionally sufficient and there is no right of recovery to the property, but only an action for money damages. Can you please turn the next slide? Way. Private deed restrictions, and this is important in the context of condos. This means the master deed and bylaws, and in the context of homeowners associations with regard to the declaration of covenants and restrictions and bylaws. Other interests that are not lost are interest of a lessee or an assignee of an interest of a lessee under a recorded oil or gas lease, interest in oil or gas that are owned by a property other than the owner of the surface that have been preserved as provided in the Dormant Mineral Act, and interest in property accessible as personal property under MCL 211.8G. After the redemption period expires, the General Property Tax Act allows the foreclosing government unit to sell these properties at a public auction to recoup the unpaid real property taxes, penalties, interest, and fees. Because of a recent case, Raffaele versus Oakland County, former owners of property foreclosed and sold under the General Property Tax Act are now entitled to claim these sale proceeds in excess of taxes, interest, penalties, fees, and expenses of sale. As of date, a claim for sale proceeds may only be made for foreclosures occurring after 2020. Its application to years before 2020 depends on the Michigan Supreme Court finding that this case will apply retroactively. Now, to claim these potential proceeds, you must begin by filing the form 5743. We've included that in Appendix B. It is labeled the Notice of Intention to Claim Interest in the Foreclosure Sales Proceeds with the Foreclosing Government Unit. This must be filed by July 1st. Again, the timelines are incredibly important with this. The Foreclosing Government Unit will respond to you by January 31st following the foreclosure auction with a Form 5744, which is titled the Notice to Claimant to File Motions with the Circuit Court. Now, if there are actually surplus proceeds remaining for the property, the claimant may then file this motion with the Circuit Court between February 1st and May 15th following the receipt of this notice from the Foreclosing Government Unit. Thereafter, the courts will then set a hearing date and time to determine claim payment. It's important to note that after the property is foreclosed on, it's first offered to the local unit of government. The timing of this is done before the first auction, and the local unit of government must pay either the higher of the minimum bid placed at the auction or the fair market value of the property. The fair market value of the property is determined by the notice that I discussed earlier and is attached as an appendix as Form 5743. Now, what does the buyer receive at the auction? The sale deed vests fee simple title to the property and the buyer. The buyer is entitled to a deed within 14 days after full payment to the foreclosing government unit. Again, this purchaser title is subject to those interests we discussed before that cannot be foreclosed on by the circuit court judgment. And then we're moving on to what if the foreclosed property is a platted lot or a condominium unit? Thank you.
Okay, there's a couple things I want to point out before we get into this part. One of the things is back on Crooked Creek, it came out on March 16th. We can't take any credit for the fact that we asked for a decision prior to our putting this on for March 24th. Besides that, we're not real enamored with the fact that any kind of notice is grounds enough to foreclose out the interest in the property. The other thing I wanted to point out is Brooke has mentioned that notice has to be given to anyone who has an interest in the property that the taxes are coming up for foreclosure. One of the things that we frequently get in the mail is a notice from the treasurer, especially if our office has filed a lien, the affidavit in support of the lien. They automatically, anybody who's got any kind of interest of record, they send that notice out, and then we take those notices and send them on to the board saying, okay, now these are your options, what you can do about it, which is something not germane to this discussion today, but in the future, if the question arises, please don't hesitate to ask us. But then they ask us, why do we send it? Because we get to know, well, because our obligation to you as counsel is to let you know that there's something happening with this unit, and if you're owed money, there's something that we all need to do about it. So I thought I would point that out. So now going back to this slide, what if now this is tax foreclosed property, is platted lot or a condominium unit. Unfortunately, I have a case that's called Harbor Watch Condominium Association versus Emmett City Treasurer, rising from upper Northwest Michigan. And basically what happened and what we used to do in the past was after the foreclosing unit, the county didn't have the sale, but the expiration of redemption expired, I should say, I'm sorry. we would send over a bill for assessments and say, well, all right, you guys own it now. Now you got to pay assessments. And that was the subject matter of this particular case. And what happened was the court ruled that, well, no, it's a taxing entity and it's an involuntary purchaser performing a government function. So you got a couple of questions here you need to ask. Number one, in the Condo Act, it doesn't say whether you're a voluntary or involuntary purchaser. It says if you own the land, you need to pay the assessments. Well, unfortunately, the king can do no wrong, and kind of like government immunity, they're saying, well, they're performing an important governmental function. Therefore, as long as they foreclosed and they took title by virtue of the foreclosure, then they do not have to pay any assessments. Would note, however, though, anybody that they transfer to after that date is going to be liable to pay the assessments. But the association fees are canceled as to a foreclosure judgment of the association of the property. It's specifically extinguished under the statute recited. So, in other words, what you have in terms of you're trying to foreclose the lien, then you can't foreclose the lien because of the fact that your lien's extinguished. However, you may still have a civil remedy, because if you read in your documents, it says we can either foreclose on the lien or we can file a civil action to collect the personal debt, or both. And you can still go after the former owner for the personal liability via a general civil lawsuit. The exceptions being obviously if there's a bankruptcy filed, which Melissa handles for us, or if the governing documents provision has something indicating something to the contrary. In HOAs, the former owner can still be held personally liable and be sued by a general civil action. However, some of the HOA documents that I've seen provide that a successor in interest is not liable for the assessments of their predecessor unless they expressly agree to assume same. And sometimes that's the same thing, which we'll see in the next slide with purposes of a mortgage foreclosure. Next slide. What if the mortgage foreclosed property is a platted lot or condominium unit? This is the circumstance where the mortgage company forecloses because of non-payment on the debt of the mortgage. Well, in a condos, the foreclosure of a first mortgage recorded before an association's lien takes priorities and again extinguishes the association's lien rights. Okay. Please note that it's a first mortgage recorded first. If it's a second mortgage and so on and so forth, it does not have priority. If it's a mechanic's lien, a construction lien, or anything like that, other than a tax lien, the association's lien is subordinate to the first mortgage. Please note that we used to file lawsuits and say, well, no, the original mortgage was with Michigan National and was taken over by Bank of America. Therefore, you're not the first mortgage recorded first. That proposition was originally upheld by an Oakland Circuit judge. And then ultimately, subsequent cases, that decision was reversed by the Court of Appeals that said, no, if it's an assignment of the mortgage, it's still the first mortgage and they inherit the rights of the first mortgagee. So you've got to find out what the mortgagee is. If they are the one that took over from the first mortgage recorded before your lien's in jeopardy. In HOAs, most of the documents provide that a mortgagee has priority over the association, and the association has lien rights. Some documents, I've seen this in HOA, say, well, if the mortgage is foreclosed, all indebtedness, both the lien and the personal liability, is extinguished. And in that case, the civil remedy may not be available. So again, you need to go through your documents, typically in your declaration where it talks about the annual maintenance charges and so forth in HOA, or in the bylaws, you may see this language. As I mentioned in the last slide, the buyer of a lot or condo unit is required to pay future assessments of the association. In that case, the Twigga case, that was the holding in that case, that no, even though the taxing unit foreclosed on it and got a judgment, it got title, but you got title after that, so no, you're responsible for the obligations after that date. So moving on to our last slide, I believe, and we can entertain some questions. There's some takeaways here. Time is of the essence. Don't wait until the next monthly board meeting to discuss this. If you get notice of it's up for foreclosure or forfeiture or something, please take action. Contact your association counsel to find out what rights you have or what you need to do. Sometimes these assessments are huge because of COVID. They haven't paid an assessment for a year or 2 years or anything. So the question being is, what do you want to do in order to preserve the association's interest? Well, do your documents need amendments so the association can fully protect its interests? Do your documents allow for the association to say, okay, we're going to go ahead and pay these taxes and proceed with our own foreclosure, and we'll sell it. And obviously it depends on the value of the unit, whatever, but we'll sell it, pay off the first mortgagee and pay off our money and maybe make a few extra dollars. I don't know. That can happen. It has happened before. We've been successful with that circumstance. But the bottom line is it clear that your documents can do that. In the amendment documents that I do, a lot of times I'll say that the association can pay off any lien on the property that it needs to protect its interests. It's extremely important that you consult the association counsel. I cannot overemphasize this because of the fact that there are so many rights and remedies that are extinguished that need to be sorted out in terms of what you can do to protect the association's interest, because otherwise you're sitting on unpaid dollar amounts that could be years in the making. So the tax man can be scary, but not if you understand the process and act timely. And I think I'm politically incorrect there. I think we're supposed to say tax person, Melissa. Sorry about that. So we're kind of opening the door unless, Brooke, do you have any other comments that you wanted to throw in?
No, thank you.
Anybody have any questions? Melissa, has anybody out there got some questions? I know we threw a lot of information at you in a very short time period. Like I was going to say, this is a general overview of the particular facts and circumstances of your situation. May require that there's further evaluation of the facts, obviously.
Thanks, Melissa. Hi, everybody. I just want to give a quick mention of the Michigan Legislative Action Committee for the Community Associations Institute. While I have you here as a captive audience, I am one of the chairpersons of the committee, and we are working on lots of different issues, not just tax issues, but other legislative matters that affect community associations. And we really need your support to make our laws better for condos and HOAs. And that's what we do. And I just wanted to get a mention of the committee out there to raise awareness that, right now we're actually working on helping to create a bill to remove discriminatory covenants from HOA and condominium documents. And we're working with Representative Sarah Anthony on that. So that's the type of thing that you can help us get done. Obviously, lots of other issues, the Marketable Title Act issues, and any other issues that come up over the years. But we really need your support. So I direct you, if you can, please contact me. My email is gfiorito@zdfattorneys.com, or you can check out our website. We have a web page on there that's listed on the slide. And if you check that out, there's ways where you can actually make donations. We have a $1 a door campaign where associations can donate depending on the number of units or homes they have. So again, just trying to make you aware that we are trying to make the laws better. There is a way to do that, and LAC is doing that, and we need your support. And that's all I have, Melissa.
All right, and I do not see any questions in my chat. And Greg, do you have any questions? I don't think so, because he hasn't let me know. So if you think of questions later, or if you would like a copy of the presentation, you can reach out to me at mfrancis@zdfattorneys.com, and I can get you a copy of the presentation. If you have specific questions for Mr. Wagner, you can email him at rwagner@zdfattorneys.com. Specific questions for Ms. Jordan can be emailed to her at bjordan@zdfattorneys.com, or you can reach both of them in our Mount Clemens office at 586-465-1330. And we invite you to enjoy your lunch with us on Wednesday, April 21st, 2021 at noon, when Stacia Miller and guest Susan Hahn of Customized Property will present Build a Better Budget, a line-by-line tutorial via Zoom and Facebook. Thank you so much for joining us, and I will stay on for a few minutes in case you would like to send me your email in private chat. But have a wonderful day and happy spraying. Thank you.